people here now, so please take the roll.
Judiciary will come to order.
Okay, we're going to take up two bills by request first, and then we're going back to the agenda. Senator Edwards is going to do 302. I think he's got some people to.
You want to bring in? It's your bill.
It is my bill.
Okay. Senate Bill 302. There's a substitute that's been handed out. Everybody got the substitute? I think we got it fixed. There are a number of issues. It has to do with the petition for guardianship. It provides that any person, including the Community Services Board and local and state government officials, may file a petition for appointment of a guardian. It also provides that a guardian need not, this is existing law, need not be appointed for a person with a health care decision where a health care decision is made pursuant to the Health Care Decisions Act unless the court determines the decision is not in accordance with the wishes of the principal.
Okay, the substitute, and the last part, the substitute does what the last substitute did.
Yeah,
right?
and then it has a study to study further some of these issues.
Okay, so we have it properly before us to have a motion to adopt the substitute. Okay, motion and a second to adopt the substitute. All in favor, say aye.
Aye.
Okay, the substitute's for you, Senator Edwards. You said some people here to testify.
Yeah,
about this bill.
anybody here want to testify, and then there's somebody online, I believe.
Mr. Chairman, there's a Valerie Suggs online.
Okay.
Okay, well, then, 2 minutes aside. Let's
Yeah,
go.
you're 2 minutes aside. Okay,
You're in
yeah.
favor of the bill.
The first person here is Amy.
Good morning. My name is Amy McCullough. I'm here from the Virginia Academy of Elder Law Attorneys. We support the substitution in part, but we do not support all. With regard to the new language at line 11, adding Community Services Board, we do support that language. That appears to be a necessary clarification in the code, and we think that that would be very helpful to families who need to have a guardian appointed. With regard to the language beginning at line 77 through 80, we cannot support that language. That language essentially takes the Healthcare Decisions Act, which is an act that provides instruction and guidance to healthcare providers in emergency situations, and shoehorns it into the guardianship code where it's really not intended to go. Both the Healthcare Decisions Act, which I deal with frequently in my elder law practice, talking to clients, and the guardianship statutes, which I also deal with very frequently. I've been a guardian ad litem for 20 years. These are both designed to strike a fairly delicate balance, and throwing in sort of a Band-Aid remedy to upset that balance, I think, has more potential to create bad law
Is this existing
than it
law?
does to...
This is existing law.
The Healthcare Decisions Act is existing law. However, when we state that a guardian need not be appointed when the Healthcare Decisions Act is being used, guardians do a lot more than simply make medical decisions. Guardians sometimes make decisions for housing. They will make decisions for, for instance, enrollment in a day support program, for rehabilitative services. The Healthcare Decisions Act is available certainly for folks who need to have medical decisions made, particularly in an emergency, and folks who do not have guardianship already regularly avail themselves of this because the medical providers are trained to substitute a decision maker when they're working with someone who doesn't have the ability to make a decision.
You would agree that is, all this does is put the Healthcare Decisions Act so people realize that this is, the Healthcare Decisions Act provides that if a patient is determined to be incapable of making an informed decision, then the doctor can look to certain health family members, including the parent of the patient. And that's all it's doing.
I agree that the Healthcare Decisions Act is current law, but this goes somewhat beyond that because it places it into the guardianship code as a guardianship substitute, and that's not what the Healthcare Decisions Act does.
Well, it says that a guardian
okay.
need not be appointed where the Healthcare Decisions Act applies. That's what it says.
a running
Okay.
debate.
All right, go ahead. Anything else you want to say?
Yeah, no, I would just simply say that on behalf of VELA, we would request that the language at 77 through 80 be stricken, but we're in agreement with the new language at line 11.
Okay, thank you
thank
very
you
much.
very-
That
next.
doesn't really count against the
Anybody-
time limit.
anybody
because
else?
There were somebody online that was partially for, partially against.
I don't know.
I'm chairing the committee, the second.
Go ahead. Yeah.
Mr. Chairman, we do have one person online.
Okay, let that person,
Valerie Suggs, please unmute and begin your testimony. Valerie Suggs, would you please unmute and begin your testimony?
She's bored.
Hello?
Yes, we
Hi.
can hear you.
Hi, my name is Valerie,
pretty nice.
and I am a parent of two children with special needs. One of my son is 22 years old, so he has been through the whole guardianship process. And there's some things that I wanted to share of my experience. Our guardianship for my son cost us personally $2,500, and that was 3 years ago. My daughter is going to be 17 on Wednesday, so we could start her guardianship up in approximately 6 months. Now that cost is closer to $4,500. Public entities such as the school and community service boards should be informing parents about the process for guardianship. In my experience, my fourth point is that we do support, my husband and I, an amendment, not because we agree with everything that's in it, but because it is heading us in the correct direction. A lot of our friends with special needs children can't afford the out-of-pocket expense to getting their disabled or handicapped adult child guardianship. And when that happens and there's a medical emergency, that disabled adult does not get the care that they need. And it just makes everything so much scarier for the disabled adult and for the family as well.
okay, thank you very much.
You
ma'am.
fully support the bill, is that right?
Yes.
Okay.
Okay, Senator Stewart, you indicated you had an amendment?
What's the amendment?
Oh, I'm sorry.
Is there a amendment? Shit.
Senator Stewart's working on an amendment. Do we want to let this bill go by for the second? And Senator Obenchain, you've got witnesses for, wait, Senator Stewart's got an amendment. I apologize. 302.
Mr. Chairman, I would move that on line 79, after unless we strike, the court determines that the decision is not in accordance with the wishes of the principal, and add there is a need for decision-making outside the purview of the advanced directive. I think that Ms. McCullough makes a good point, and I think that fixes it.
This is where there is no advance directive under the Healthcare Decisions Act. There is none. That's the decision, that's why the healthcare decision is made by the doctor in connection with the family members. That's the whole point of it.
Right, that's what I was trying to say, yeah. It would be unless it's outside the purview of the director.
There is no,
But if there's no
that's,
directive.
there is no advance directive under the Healthcare Decisions Act. That's why it's
I
here.
tried it.
Yeah, okay, all right, okay.
Okay, do you want to go forward with the amendment, Senator
If
Stewart?
you all don't like it, we don't have to. I thought
All
it
right,
fixed it.
all right. I move the bill be reported.
Okay, there's a motion to report. Are there other motions? Is there further discussion? If not, please open the roll, Vote ayes, vote to report the bill. Okay, Senator,
I have 11-0.
Senator Obenshain, you have a
Officials.
bill with a witness, and I think that's 229, is that correct?
Yes, Mr. Chairman, I've got two bills, but one, I have a prosecutor who needs to be in court shortly. It's Senate Bill 229. We have spent a good bit of time working on trying to make accommodations for persons with autism and other disabilities, and providing for opportunities for deferred dispositions for certain crimes. And in passing these bills, we created a set of exemptions for certain violent crimes for which the deferred disposition is not available. Ms. Eldridge, who's the Deputy Commonwealth's Attorney in Rockingham County, has brought this to my attention, that these deferrals or the exemptions do not cover indecent liberties or indecent liberties for persons in a supervisory or custodial relationship. And this bill simply would add those to the exemptions that are not eligible for those deferred dispositions. And I'll let her testify in just a second, but the fact that somebody has an autism disorder it doesn't make them less dangerous if they have committed these violent crimes. And these deferred dispositions allow people to avoid being listed on the registry. And this may be a serious sex crime that was committed, and this may be the only barrier that prevents or enables people to understand, that this person could pose danger. So I'd like Ms. Eldridge to testify.
She's online, but there's nothing in here that directs the court to defer the disposition.
No.
The court only has the authority. So
Yes.
And this just takes the authority away in certain situations.
Let me let Ms. Eldridge address it, and she may be better able to answer your questions.
Ms. Eldridge, can you unmute?
Yes, sir. Good morning.
Morning.
Thank you, Mr. Chairman and members of the committee, for the ability to allow me to testify remotely today. Senator Deeds, yes, I can answer your question. It does take away the authority from the judge just in certain circumstances to defer. It would still allow deferral on almost all code sections. The General Assembly, as I'm sure that you all are aware, as you passed the legislation recently, did allow for deferral in almost all criminal offenses. However, you did take away that deferral in certain cases to include violent crime cases and almost all sexual assaults. All of the traditional sexual assaults like rape and sodomy, aggravated sexual battery, those are not subject to a deferral. However, indecent liberties in a supervisory capacity, and other internet crimes against children were not excluded from that. Indecent liberties in a supervisory capacity, for example, could be a teacher or a coach or another person in a guardian type relationship that has sexual relations.
Senator
or other.
Sergel has a question, if that's all right.
Yes, sir, Senator.
Thank you, Mr. Chairman. I just want to try and focus the discussion a little bit. I have a question for council. So we passed Section 19.2-29802 in the 2020 special session. My recollection is that statute allows for a deferral and dismissal in any case of any kind whatsoever, but it requires the consent of the Commonwealth. And it sort of made this statute redundant in some ways, but am I correct that the only difference is in this statute, the deferral can be done over the objection of the prosecutor?
That's correct, Senator. Yes, sir.
Yeah, okay. All right, I just want to try and make sure how clear we are. So we're basically just talking about a small subset of cases where a prosecutor can be overruled.
Yes, sir, Senator. In most cases, a prosecutor can be overruled by the judge, which certainly makes sense in a number of crimes. The issue with the sexual assault crimes, senators, is that a deferral in a sexual assault case has somewhat larger ramifications in the sense that if it does result in a deferral and a dismissal, the offender will never be placed on the sex offender registry, which will have not only limit the notice requirements to the public that this person is a sexual offender, but also remove some of the supervision requirements that can come even after the offender is off of probation. For example, having to report their employment and their residential addresses to the sex offender registry so that tabs can be kept on where that individual is, that they're not close to schools and things like that, for example. We would certainly say, at least from my perspective as a sex crimes prosecutor for over 15 years, that even if the offender does have a mental health disorder, it doesn't make them less violent. It doesn't make them less of a risk to reoffend against children. And that certainly is the concern, is that if there was a dismissal, they would not be on the Virginia sex offender registry.
Thank
And
you
the
very
senator
much.
is, yes, sir. Thank you, sir.
I think we get it. I didn't count that toward anybody's time limit. But
Mr.
now I'd
Chairman.
like to have
Mr.
like
Chairman.
2 minutes for, 2 minutes against. Senator Morrissey's got a
Thank
question
you.
first.
A question for the prosecutor. You mentioned the mental disability a couple of times, and you mentioned, or the patron, on the autism spectrum, but this also deals with an individual who is intellectually challenged, correct?
Yes, sir, Senator. If they meet the disability requirements in, I believe it's 37.2-100, and the judge finds that that is directly related to their crime, that does cover, yes, sir.
So further question. Last question.
Senator Morrissey.
We used to call somebody that was mentally retarded. We have now changed that vernacular and we use intellectually disabled. So if somebody has a very, very low IQ, this would capture that person. Is that right?
It could capture that person, Senator, and also there is the ability for an agreement under the other code section for a deferral if there's an agreement with the Commonwealth and the defense attorney.
Okay, thank you.
Thank you.
Thank you, ma'am. Okay, now 2 minutes aside. People that are in favor of the bill, I'd like to hear from first. If you're in favor of this legislation.
For those attendees in the Zoom room who would like to speak in favor of the bill, please raise your hand electronically now. Mr. Chairman, we do have 3 people online.
Okay, 2 minutes.
Jude Harrison, please unmute and begin your testimony.
I'm sorry, I am opposed to the bill. You want me to go ahead and?
Yes, go ahead.
Teresa Champion, please unmute and begin your testimony.
They're all opposed.
They're all opposed.
Yeah.
Yeah, all 3 of them are.
Who's next?
Okay, are there people in support of the legislation? Then we'd like to hear from people that are opposed to the legislation.
Mr. Chairman, we do have 3 people online that are going to go.
They have 2 minutes.
Jude Harrison, please unmute and begin your testimony.
Hi, I'm Jude Harrison, and I'm the Director of Communications for LRID. We strongly oppose this bill. In 2020, Senator Obenshain voted yes for SB 133, which allowed for a judge to defer or dismiss. So, I feel like, why are we doing this? Why are we walking back a law that hasn't even had an opportunity to really be used yet? At least not a lot, enough to do this. So, I'm sorry.
Okay, next speaker.
Teresa Champion, please unmute and begin your testimony.
Good morning. My name is Teresa Champion. I'm with the Virginia Autism Project, and we do oppose this bill. Whether someone commits one of these crimes or not, they're still autistic. This is not a mental health disability. This is a developmental disability. So biologically, they develop, but they're delayed with other issues. Prison's not appropriate for autistics, but they should be deferred for therapy and treatment. A better approach is to make sure that autistics get adapted family life curriculum in schools, which they do not now in Virginia. Thank you.
Thank you, ma'am. Next.
Tanya Milling, please unmute and begin your testimony.
Hi, I'm Tanya Milling, Executive Director at the ARC of Virginia, representing people with intellectual and developmental disabilities, including autism. We do oppose this bill. There are the majority of the cases, individual advocacy cases that we take on that relate to what was SB 133 really is related to this specific area. Often people are unintentionally and unaware of breaking the law because of those developmental issues. And this is only to give that judge the opportunity and not require, so that we can make sure to defer people.
Okay, thank you. Senator Peterson's got a question.
Actually, I've got a motion. Let me speak to this. I actually was reading.
Want to let Senator Obenshain finish up?
Yes, I'm sorry.
Close
Yes.
out?
Mr. Chairman, members of the committee, and nobody wants to put people in prison who simply need help. But as the last speaker indicated, some of these folks who would be covered by this don't realize that they are committing criminal conduct. Yet they elude listing on the sex offender registry. They may live next door to a child care center. This is simply to prevent additional harm to the community, not to put people in prison who don't belong there. It's a loophole. Yes, I voted for the legislation last year, and I would do so again. It doesn't mean that in complex legislation that we always get all parts of it right.
Senator Peterson.
First of all, I apologize, Senator Obenshain. I didn't mean to cut him off, and I think this is a good dialogue. I'm going to move to pass the bill by indefinitely and just speak briefly to that. If you look at this code section, which is 18.2 dash, I think it's 372 et sequence, it's mostly either production or distribution of pornographic images, exposing yourself, masturbation publicly. Unfortunately, it's a lot of things that people that are developmentally disabled may be more likely or more prevalent to do. And the bottom line is, all we're doing is giving the judge the discretion to take that into account. So I think your original vote was the right one, Senator. So I would move we pass this bill by.
Second.
Okay, I got a motion and a second. Are there other motions? Is there further discussion? If not, please open the roll. Green votes, vote PBI. Senator Obenshain, you have another bill.
I do, and thank you for taking this. I have Senate Bill 554, and this is essentially same as bill that I brought last year dealing with folks who take advantage of elders, exert undue influence, and procure a will that benefits themselves. It's bill in a very similar form passed out of this committee 13-1 and out of the Senate 38-1 last year. You may recall that the dialogue last year surrounded a decision by the Virginia Supreme Court in Parson versus Miller, in which the Supreme Court addressed presumptions that arise in undue influence cases. It has long been the law of Virginia that if a testator is mentally feeble and someone in a confidential relationship takes steps to procure a will that benefits them, like a caregiver who takes this charge of theirs to the caregiver's attorney and secures a will in which the caregiver is the beneficiary, the presumption is that that's a product of undue influence, because it's very difficult to prove undue influence. It's a circumstantial evidence type offense. But in Parson versus Miller, the Supreme Court of Virginia said that you get the presumption, but the presumption disappears completely if any evidence is presented indicating that indeed that was the intention of the testator. Like the lawyer who drafted it may say, seemed okay to me. Pop, the balloon is gone. There is no presumption, and it is virtually impossible to protect a family being taken advantage of by an interloper, by a person in a confidential or fiduciary relationship. It may even be one child who does that. This bill says that
the jury is to be instructed as to the existence of that presumption, and the jury shall presume that the will, if the presumption arises, jury shall presume undue influence unless the evidence indicates otherwise. It still allows the jury to say the totality of the circumstances indicate that this was indeed the testator's will.
Well, Senator, isn't that always the case, the presumption lets the jury decide?
It used to be. Now, a jury is virtually never going to be instructed on a presumption, because in virtually every case, there is some evidence that that is the intention of the testator. It may be a witness who says, seemed okay to me. And the court analogized this to a balloon and a pin, and that the slightest evidence that it was the intention of the testator is enough to pop that balloon, and the presumption evaporates, totally disappears. And before Parson, we all thought that was the law. We thought that a jury was going to be instructed as to the existence of a presumption. They could discard it if they believed that the evidence indicated otherwise. But this is an ongoing battle that I've had with the will writers in the trust and estate section and other groups of primarily estate planners who, of course, want to protect a written document. But quite frankly, elder abuse is running rampant. More than $1 billion a year is stolen. As a matter of fact, later this week, I'm going to Northern Virginia to testify in a disciplinary action involving a lawyer who wrote a will 10 days before a woman's death, leaving himself virtually the entirety of that estate. And the contingent beneficiary, in case he didn't survive, was his son, who the testator had never met. And there was a notary public who said, all seemed fine to me.
Is there anybody?
All seemed fine to me.
Is there anybody in favor of the bill that'd like to speak?
Bill Hopkins is on the line.
Okay, Bill Hopkins, I happen to know him. William Hopkins Jr., you online?
Mr. Chairman, he is online.
And before Mr. Hopkins, I've got a substitute, which is virtually the same as last year's bill.
Second. All in favor of the substitute, say aye. Aye. Opposed, no. Motion carries. Go ahead. Bill Hopkins, are you there?
I'm here.
Okay, Bill, speak. What do you think about the bill?
I think it ought to be passed. I'm Bill Hopkins. I'm a lawyer in private practice in Roanoke, Virginia. 6 months ago, I was reading an editorial that made me think of Senator Obenshain's bill. There was a sentence in it that said, there's a reason why telemarketers target the elderly. As you get older, you get weaker in body, weaker in mind. You get more dependent on the people that are providing services to you. You become more gullible. Undue influence is never exercised in the open, or rarely. In order to prove undue influence, you've got to have the benefit of a presumption. This bill is really quite modest in one way. Is all it's really doing is returning us to the law before Whedon versus Whedon, which was a 2012 case, and Parson v. Miller, which was a 2018 case. I know the VBA had weighed in last year and said that it's going to open the floodgates to undue influence cases. But that wouldn't be the case, because all we're really doing is returning to the 2012 law, and there was no problem then. Senator, I support the bill, and I'd ask y'all to pass it.
Anybody else want to speak in favor of the bill?
For those attendees in the Zoom room who would like to speak in favor of the bill, please raise your hand electronically now.
Anybody else want to speak against the bill?
For those attendees in the Zoom room who would like to speak in opposition to the bill, please raise your hand electronically now.
West Virginia Bar here. Oh, here you go.
Prince of Darkness.
Mr. Co-Chairs, Jeff Palmore on behalf of the Virginia Bar Association. Appreciate Senator Obenshain working with us and definitely appreciate his passion about these issues. Our primary concern, as we raised last year, is that this legislation, if passed, would lead to valid wills being overturned. The Virginia Bar Association's Will Trust Estate section involves both will drafters and litigators who litigate these issues, and it was their opinion last year and again this year that this would lead to valid wills being overturned. The most common instance that this type of situation would come up is where there's multiple children in the family and the parent decides to leave one child with more of the estate, whether it be monetary assets or even more likely a home or land, because late in life that child has stepped up and helped take care of the parent in their later years, and the parent wants to leave the house with that child. This legislation would allow for a situation where the elements that you have to put forward evidence of to get the presumption of undue influence are not that hard to find. It's that the testator was old. Well, lots of people that write wills are old. Number two, that the beneficiary stood in a relationship of confidence or dependence. Well, in the instance of a child, that would be very easy to put forward evidence of. And then the testator previously expressed an intention for contrary disposition of the assets. That happens all the time in family situations. So in those cases, the disinherited child will use this law to have the will thrown out and have it replaced with intestate succession. And there's other instances we can come up with. Certainly the ones that Senator Obenshain points to are very tragic, and we don't want those to happen. We want those situations to be overturned, but we think this is the wrong approach that would allow for valid wills to be overturned. And I see Senator Morrissey raising his hand. I might defer to the folks behind me that are elder law attorneys that deal with these issues on a day-to-day basis.
Senator Morrissey has a question.
But I'm happy to answer any questions.
Jeff, if you've got to defer to somebody, I understand that. I'll just say this. Whenever I hear a person in your position say, I definitely appreciate so-and-so's passion, it's usually a but.
That's right.
What about this, though? The patron gave an example where a lawyer put himself in a position to benefit, and then if he didn't succeed, his son, who had no contact with the individual who passed, would benefit. Or the situation where a caregiver comes in a month before the individual dies, and all of a sudden, that caregiver has been left everything. What about those examples where we can see that there's elder abuse? How do we capture those and allow for the presumption, which you would agree should be instructed to the jury? How do we capture those egregious cases?
Mr. Chairman, Senator Morrissey, I think the legislation could be crafted to deal with those types of scenarios where a lawyer who writes a will, and there was legislation we dealt with a few sessions ago, I think, to deal with some of those issues, where a lawyer drafts a will to leave himself the assets. Obviously, that's a situation that we could legislate against. But and then the caregiver situation. I agree that those are situations that perhaps a different standard should apply. But
we got to move along.
Yes, sir.
Senator Teague, you have a question.
Thank you, Mr. Chair. Mr. Palmore, a question. Mr. Hopkins, who just testified, said that this bill just restores us to what we were like in 2012 before that decision. Does the bar dispute that?
Well, I'd let Ms. McCullough answer some of those questions because she's been dealing with these issues.
All right, Ms. McCullough, elder law expert.
Good morning. My name is Amy McCullough again. I'm here from the Virginia Academy of Elder Law Attorneys. We appreciate Senator Obenshain hearing our concerns and amending the bill. However, VELA still cannot support SB 554. I would just want to remind everyone that historically in Virginia, we have given a great deal of deference to the wishes of a testator as expressed in his or her will. And this bill, we feel, would undermine the security of estate planning, particularly for our older clients. While litigators tend to see the very worst cases, for every one of those really egregious cases that I often will refer to litigators, such as Senator Obenchain or others, I'm seeing families coming in wanting to do estate plans or wanting to amend their estate plans, and I'm getting 15 or 20 families who could have concerns about the security of their wills if this were to become the law. Because in the vast majority of the cases I see as an elder law attorney, nothing untoward is going on. I would say probably for every one situation where there's perhaps some elder abuse and I'm referring them on to a litigator, I'm seeing 15 or 20 situations where there's not abuse. And these are people who may be elderly, but who are very well aware of who they want to leave their estates to, how they feel about their various family members. Some of them are very certain about how they feel about their family members and what they want to do with their estates. And I'm concerned that with this bill, we would be creating a situation that would, like I said, undermine the security of their estate plans and also foster more litigation.
Okay.
When I have folks coming to see me, they are generally very concerned with what can I do to make sure my property gets to where I want it to go, but also what can I do to make sure this doesn't end up in court? I'm very often asked, what can you
Mr.
put in my
Chairman,
will to make sure this doesn't get
Senator Peake has
Question
a
to the
question.
So the same question I had for Mr. Palmore. Mr. Hopkins testified that this bill will return us to how we were in 2012 before the Supreme Court decision. Do you dispute that?
I think this may go beyond that, Senator. I will confess I did not pull Wheaton versus Wheaton before I came in here. I did read Parson v. Miller and some of the other related cases from that. I'm not sure that this would necessarily just take us back to 2012, however, because what this bill would do is, as Mr. Palmore stated, the bar to establish the presumption of undue influence is fairly low.
Okay.
And
we have to
that
move-
presumption would stay in place throughout the entire trial, putting the burden on the proponent of the will until the very end. And I can't say that I think the burden was always on the proponent of the will, Senator.
Okay, Senator Stewart.
Thank you, Mr. Chairman. Ms. McCullough, give me an example of where the presumption of undue influence would apply.
Well, the presumption of undue influence arises, the first prong would be getting evidence that the testator was either old or enfeebled. That's usually pretty easy. We just have evidence. Testator was 85 years old when he drafted his will. We've got the first prong. Second prong, testator named a beneficiary who stood in a relationship of confidence or dependence with the testator. For some of my clients out on the Northern Neck or down in Caroline, where they're more rural, they will often have a child move in with them on their property. And if that child is named as a beneficiary, they're often being named as the one who will inherit the house because they moved in and took care of mom or dad. That's a very frequent arrangement in some of the more rural areas I practice.
We do have to move along.
Got prong 2. And then prong 3, testator previously expressed a contrary intention. That can be as simple as, well, back before testator was old and sick, testator told somebody, I'm going to leave everything equally to all 3 of my children. And that intention was expressed before the testator was 85 years old and had son or daughter move in.
Yeah.
So we're there already.
We need to move along. Is there a
Mr.
motion?
Chair?
Yeah. Yeah, Senator who?
McClellan.
McClellan.
Senator Obenchain, this substitute is identical to the bill that passed the Senate last year, 38-1.
Well, no, it does the same thing. It guarantees, it's simply, it is essentially the same thing. It restores the presumption. It says that the jury, and a presumption has to be something that jury shall presume.
I'm trying to help you.
It puts shall, it puts shall instead of may in and moves forward.
Okay.
Go ahead, Senator McClellan.
It's not that different from what we passed,
No.
38-1, so I move to report.
Then moved and seconded the bill be reported. All in favor of the motion, vote aye. All opposed, no.
Ayes 14, noes 1.
14-1. Okay, thank you, Senator Obenchain. That's all you got?
That's all I got.
Okay.
You
the
need
next
more?
bill- We'll go down the list. Senator Peterson has Senate Bill 206, Historic Preservation.
Yes, sir.
Our historian here.
And if you don't mind, I'm just going to do it from the dais so we can move quickly. I'd like to make, this is Senate Bill 206. This went through general laws, and then I sent it back to committee because, quite frankly, I didn't think I had it right. So what I'd like to do is offer some amendments from the dais here. If you go down to line 40 and 41, this is who has standing when a historic property is being redeveloped or impacted in a way that threatens a historic designation, who has standing to challenge that. And what I'd like to do is interlineate after where it says the applicant, comma, then put any adjacent landowner, comma. I move that First Amendment. I'll move that if I can get a second.
Second. All in favor of the amendment, say aye. Aye. Opposed, no. Motion carries.
Okay, now the second part is, it says, or any resident of the locality who. I'd like to change that to any organization dedicated to historic preservation which. And if I can get a second to that, I'll explain that.
All in favor of the motion to approve the amendment, say aye. Aye. All opposed, no. Motion carries.
Okay, here's what I'm trying to do. There are historic preservation organizations that in many cases helped write the historic ordinance code, and we have one in Alexandria, and this is the historic Alexandria case Supreme Court decided last year, which then have been ruled to not have standing when they get involved in these cases and try and fight to keep buildings that are historic preserved. And this would simply say that they do have standing. And again, these are nonprofits that were actually involved in the creation of the ordinance. I see Senator Stewart shaking his head, and we're going to be opposed on this. But I think this is a very narrow class of organizations. You're not throwing the door open to every Tom, Dick, or Harry, or whatever the female equivalent. Richard says I am. I'm not. But the bottom line is this is a very narrow class of people that were integral in actually writing the ordinance. And also, I think you definitely need to have the adjacent landowner language. So this would simply allow us, organizations to have standing to preserve historic properties.
Senator Deeds.
With the amendments, then you've reduced the standing to those people who are actually aggrieved to join the landowners or historic preservation groups.
Right.
Not any citizen in the county. Or
Exactly. You have to be an adjacent landowner or a historic organization that was involved in writing the ordinance in the first place. That's it.
All right. Now, we have a speaker who wants to speak against the bill, I believe.
Well, Mr. Co-Chairs, members of the committee, Mark Flynn, Virginia Municipal League, and I will say that the amendments today are an improvement. However, the Supreme Court has had pretty strict rules on standing and fairly consistent. The Virginia Supreme Court has been very consistent on standing in this context since the 30s, really, but started really in 1983 with the Virginia Beach case. There was a commission down there that wanted to appeal. The court said no. There was the Friends of the Rappahannock 2013, and the Friends of the Rappahannock sued Caroline County, I think it was, over a quarry, and the court said no, you don't have standing because your position is representing something that affects the public generally. And then and in the Friends of Rappahannock case, the court created a two-part test, and I would say that the first part is you have to own property nearby that will be affected by a decision. By describing it as the adjacent property probably limits that provision of the Supreme Court's decisions. That is, if I lived across the street and it was going to affect tearing down the church on Franklin Street was going to affect my property, it probably would cut me out of that. But then the second part is that you do have to show a harm to you that is different than the harm to the public generally. And that is, of course, that's the dilemma, is trying to reconcile when you have an association that is interested. It's a part of the public generally. So still have some concerns. I would also say there's actually a small technical issue on the first part. It says that if you have an application if a building that's going to be torn down, if the applicant puts an application in to put it in a historic district, that stays a demolition until that is finally decided, which is okay in most cases, But if you have a building that's really, it's really a hazard to the public, if it's really bad.
Yeah, Senator Stewart wants to ask a question.
Mark, let me get to the crux of this. As I understand the Virginia Beach cases and then the Friends of the Rappahannock case, what the Supreme Court ultimately ruled was you have to own property in close proximity to the property that's making the application or doing something, and you have to show a particularized harm to your property in order to have standing. Under Senator Peterson's bill, now anybody within this circle that he's drawn could sue over this particular issue, even if they themselves had no harm whatsoever. Is that the way you read this?
Yes, sir, I'm sorry, but it is, I mean.
Well, these are leading questions. I'm going to object.
And so
Overruled, we get to ask for leading questions
so
here. It's
from
not a court of law.
from a locality standpoint, would there ever be any finality to this? Or could it just be suit after suit after suit on these particular issues?
You only get a 30-day window to file the case.
You do have a 30-day window to appeal the circuit court from the council or board's decision. However, yes, it does, it opens up the universe of people who can sue over historic district decisions significantly. And then that means.
Would it allow, Mr. Chairman?
Yeah, Senator Stewart.
Would it now allow someone to sue over this, not because they're going to be injured by what's occurring on that property, but simply because they don't like what somebody else is doing with their property?
Yes.
Thank you.
Okay, any further questions? We got to move along. Is there a motion?
Mr. Chairman, I just need to make sure I have the amendments correct, please.
Yeah, I'll give them to you, Kristen.
Okay, thank you.
Yeah, let me move to report, and if I can get a second, let me just speak to this briefly. You know, my colleagues can't decide if I'm widening the scope or limiting the scope, but here's the bottom line. We had a situation where an organization actually formed the historic district and then was not allowed to have standing after this property had had tax benefits for 50 years and was redeveloped. It was a historic property. And again, nobody was allowed to go into court to protest that, and I feel like that was wrong. So this is a very limited remedy. I hope we pass the bill.
Okay.
Thanks.
Senator Stewart, do you have a question?
Mr. Chairman, since he didn't get a second, I'm going to make a substitute motion.
All right, it's been moved and
Well, I'm going to make a
seconded
substitute motion anyway.
that the bill as amended be reported.
Substitute motion.
Substitute motion.
With all due deference to my friend from Fairfax, I move the bill be PBI'd, and here's why. You are now opening up litigation on these types of decisions where someone simply just doesn't like what you're doing with your property, and that really is unconscionable. I've done both sides of this sort of litigation, both as representing a county and representing an individual against a county or the decision-making authority. The standing that we have now, the body of law that's been adopted by the Supreme Court or made by the Supreme Court, however you want to say it, works. You may not like the results you get, but it's really, really important that you have some harm. I mean, it's like a taxpayer. A taxpayer just can't sue because they're a taxpayer. You got to show some type of harm before you can file suit to have some impact on somebody else's property, and that's the way it should be. And this just goes way too far. It's way too broad. I'm sorry, chap.
Senator
I love you otherwise,
Senator
but this
Boyce
kills me.
Senator Boysko, you have a question?
Yes, sir.
I'm Boysko.
She's Boysko, not you.
I want to respect my colleague from Fairfax. I represent two historic districts. I actually live in one. My community feels this is a little bit too far. I'm gonna go with Stewart's.
Okay, it's been moved and seconded that the bill be passed by indefinitely. All in favor of the motion, vote aye. All opposed, no.
Ayes 9, no 6.
9 to 6, the bill is passed by indefinitely. Okay. Do you have another one?
I do have another one.
You do, Junction, Supreme Court.
Okay,
Senate Bill 715.
You might remember from the movie Spinal Tap, there was a band called the New Originals, and this is the new original substitute that I had distributed, then asked to be withdrawn. I'm going to redistribute it. So this is the substitute, which basically restores and reinstates the Supreme Court's jurisdiction for preliminary and permanent injunctions. And then there's also for immunity rulings, which may have a limited shelf life, because I think at least one member is going to make a motion to get rid of that. But the point is this, that as we've changed the jurisdiction of the Court of Appeals, which I supported, we have an anomaly in that injunctions, particularly preliminary injunctions, where you have an irreparable harm and an ongoing action where you need immediate review from a court, would have to go through an intervening appellate process, which would slow down the process. And we already have a good process that works on injunctions. It was a law that I helped to write back in 2015. I think it works very well. You get a 3-judge panel, and this would basically reinstate that process. And I'm open to amendments, but I hope we can pass the bill,
Is there
notwithstanding what
anybody
just
who would
happened.
like to speak for the bill?
For those attendees in the Zoom who would like to speak in support of the bill, please raise your hand electronically now. Mr. Chairman, there are no hands raised.
Anybody would like to speak against the bill?
For those attendees in the Zoom room who would like to speak in opposition to the bill, please raise your hand electronically now. Mr. Chairman, we do have one person on the Zoom.
All right. Who would like to speak?
Monica Monday, would
Monica
you?
Monday. Welcome, Monica. How's everything? Good to see you.
Very good, Senator. How are you? Monica Monday, on behalf of the Boyd Graves Conference. I just wanted to clarify, we do not take a position with regards to the original substituted bill as to whether these injunction appeals and immunity appeals should go directly to the Supreme Court or should retain the current process where they go to the Court of Appeals. But I did simply want to clarify that if the committee passes this bill out today, that we would ask that it retain the language that was in Senator Edwards' cleanup bill, SB 143, which references the immunity statute 801-675.5B, and also retains the language regarding preliminary and permanent injunctions. But otherwise, we don't take a position on where the appeal should be taken.
What about the bill as the substitute is presented? Have you seen that?
Yes, I have.
And you don't take a position on that?
No, we simply ask that that the original language, Senator Edwards, that you had in your cleanup bill for the Court of Appeals legislation be retained if this is reported out.
And that's in the substitute, is that right?
Correct, it is. Thank you.
Okay.
We're where we need to be. I don't know why.
All right. Any other questions or comments?
Mr. Chairman.
Yeah, Senator Serval.
Yeah, he's going to take.
Thank you, Mr. Chairman. So the way this is written, let me put it this way. I think it was either in 2019 or 15, I can't remember which. We passed legislation, I think by Boyd Graves, that allows a granted, appeal a plea and bar, granted plea and bar on immunity on an interlocutory basis. And I still think that should go to the Court of Appeals. I mean, first of all, the case law on both sovereign immunity, charitable immunity, all these immunities is not well developed. We need more opinions about it. And I also think you deserve an appeal of right on that instead of the Supreme Court deciding whether or not to let you in. And the way this is written, it takes that away. It takes your appeal to the Court of Appeals away. And I think that ought to be back in.
All right, any other comments?
I would move to strike the language on line 13 and 14 under Romanet number 4. And I think when we talked about this on Wednesday, I think Ms. Walsh pointed out that would require some significant surgery to the bill because it would require us to put back in a lot of the language that's struck in order to properly affect it. Is that right, Kristen?
Mr. Chairman, yes, Senator Serval is correct. We would need to restore some of the language on lines 60 through 63 and probably strike the words on 60 to 61 in accordance with the procedure set forth in 8.01-626, because that would only be talking about appeals to the Supreme Court at that point. So you would just have your normal appeal to the Court of Appeals. And then down on line 87, we would also restore 8.01-675.5, restoring the Court of Appeals jurisdiction over those immunity appeals.
It sounds like we ought to pass this by for the year and fix it if necessary. Yeah,
Mr.
Senator
Chairman.
Short.
Mr. Chairman, just a comment. The meat of this bill is really important.
It is.
You've got to have finality with regard to the court on these issues of injunctions. I've done these on both sides as well, and this direct appeal to the Supreme Court is very important. My question is this, and I'm not wed to this either way with regard to the plea and bar, but prior to changing the jurisdiction of the courts, didn't that plea and bar, wouldn't that have gone to the Supreme Court anyway?
Yes. Mr. Chairman.
Yeah, Senator Sherville.
Yeah, it would have, but the Supreme Court can decide whether to take it or not, and they don't take like 80% of the cases that are sent to them. So you don't get an opinion, you don't get a review, you don't find out, why they thought it was appropriate to affirm. And the Supreme Court doesn't take cases anymore. That's why we passed the Court of Appeals in part, because they don't, in our case laws, like horribly developed for a state of our size.
Mr. Chairman.
Yeah, Senator.
Mr. Chairman, I just don't want to injure this bill. I don't care about the plea and bar part. It's not that important to me. But the other part is.
Senator Obenshain, I believe you.
Mr. Chairman, if Senator Surville is effective in his effort to expand the jurisdiction and workload of the Court of Appeals, Supreme Court's going to be looking for a little bit of work. So I think this makes good sense. And frankly, immunity is so important that if you don't get finality, immunity is supposed to be immunity from the burden of litigation. And that needs to be resolved, not to go through 4 years of appeals. I think that the bill should survive intact as written.
Yeah. Kristen, don't we need to?
Can I move the report to bill as it is right now?
Kristen, first a question for council.
I can't
Do
hear
we
a word
need
you're
to
saying.
fix some of this?
John, there's a
I
motion.
know, let's hear it, Kristen.
We don't need to fix anything if Senator Surville's motion to amend the bill is not.
Okay, there's been a motion been made.
A motion to report the bill, John.
Okay.
As it is.
Motion has been made and second to report the bill as is with the substitute.
With the substitute. We already adopted it.
I think, did we adopt the substitute? No, okay. Is there a motion to adopt the substitute? All in favor of the motion, aye. All opposed, no. Motion carries. Now, is there a motion to report the substitute?
I had a motion to strike that language from the bill.
Which language?
Did you get?
The language on 13 and 14 has not been seconded yet.
Hearing no second. Let's move.
Move to report the substitute.
Okay, motion has been made to adopt the substitute. All in favor,
This is
vote
to
aye.
report the substitute, John.
Report the substitute. All in favor, vote aye. All opposed, no.
Stanley.
Ayes 12, noes 3.
12 to 3. The motion, the substitute is reported.
That's all I got, sir.
Okay. All right. Co-counsel, Senator Deeds.
I've got Senate Bill 295. I'll just do from up here. A general district court judge in Augusta County asked me to introduce the bill to kind of help him expand the number of people that he could offer behavioral health docket to. I think there's an amendment to the bill. Is that correct?
Mr. Chairman, I'm sorry. Charles went up to get something off the printer, so I don't have that right now.
Okay, well then let's just pass that one by. 296, I introduced, and that basically just puts, there's a substitute to that bill as well. Are we still waiting on Charles? Okay.
We could do 474. That's one of mine.
Okay, so 474. Senator
All right, Senator McClellan, requirement of appeals bond. Senator McClellan, Senate Bill 474.
Thank you, Mr. Chair. I have a substitute for Senate Bill 474. And what the substitute version of the bill does is it treats all indigent litigants the same by allowing indigent litigants to waive the appeal bond for unlawful detainer cases. Currently, tenants appealing an eviction on non-payment of rent can't get the appeal bond waived, but for every other case related to unlawful detainer, they can. So that's the bill.
Mr. Chairman,
Yeah, Senator Sherrill.
I have a question, patron, but the way this is rewritten, they can only get the appeal bond waived if they keep paying rent while the case is pending, right?
That is correct.
Okay, thanks.
Okay.
I move to adopt a substitute.
Second.
All in favor of the substitute, vote aye. Aye, opposed, no. Motion carries. Substitutes before us, Senate Bill 474. Anybody want to speak for or against the bill? Okay.
Good morning, Mr. Chairman, members of the committee. Christy Mara with the Virginia Poverty Law Center. We thank Senator McClellan for bringing this bill and for working with all the stakeholders. This substitute is supported by the Virginia Poverty Law Center, the Legal Aid Justice Center, the Virginia Association of Realtors, and Housing Opportunities Made Equal, and there are no stakeholders in opposition to the bill. And I'm
Okay.
happy to answer any questions.
Any questions? All right.
I have a question.
Yes, Senator Senator Peterson.
Okay, and I represent the little guys. If you have a tenant that has not paid rent for years, and you file an unlawful detainer and get a judgment, and they don't post an appeal bond, they can continue living in the property as long as they're paying current rent, correct?
Mr. Chairman, Senator Peterson, yes, as long they could request that the appeal bond be waived. There is nothing that I know of that mandates that a judge must waive the appeal bond. What this bill is doing is it is allowing litigants who are appealing unlawful detainer judgments based on non-payment of rent to have the same right as almost every other type of litigant appealing a civil case from general district court to ask a judge to waive the appeal bond.
Okay, further question. I appreciate that, Christy. That's an important distinction, and you're melting me. Okay. I'm still not a fan, but you're melting me. Okay, I'll leave it at that.
Yes, Senator Stewart has a question.
I'm sorry, Chrissy, as I read it, it says, no indigent person shall be required to post an appeal bond. Have I got the wrong substitute?
No, and in fact,
It's not permissive, it's a mandate
with this
on the
language,
judge.
yes, I stand corrected,
Okay,
Senator
all right.
Peterson. I apologize. With this language, it would be a mandate.
I'm an iceberg again. Okay.
Okay. Any further discussion?
Mr.
one way or the
Chairman,
other?
If I could, Mr. Chairman, I would say, Senator Peterson, that does still bring it in line with all of these other cases, all of these other types of cases, that no indigent person shall be required to post an appeal bond applies to everything except for
Right, but it's a
one
little
or
bit
two
different when they're
cases.
living
All
in
right, we
their
have some
house.
people on Zoom who want to speak. I'll give you 1 minute.
Victoria Horick, would you please unmute?
Good morning, Mr. Chairman, honorable members of the committee. My name is Victoria Horak. I'm an attorney at the Legal Aid Justice Center, and we support the bill. I echo the testimony of the Virginia Poverty Law Center. We support this bill because the lack of an indigency waiver in unlawful detainer cases is just an insurmountable barrier for our clients to appeal. And I know time is brief this morning, so I'll just give like one example of my own clients. Last spring, I represented a family with 2 children living in Dinwiddie County. The client had gone to court on his own for the first court appearance. He argued that he should be protected by the COVID-19 tenant protections, and the judge disagreed with him. And because he didn't have the money to appeal, he essentially had no recourse. And by the time he got to legal aid, all we could do was ask the same judge to revisit the same issue. And the judge disagreed, and he was made homeless within a week. And so what we're asking for is really that client have the same rights as any client who had greater financial means. And so we're asking that the committee vote yes on SB
Thank you.
474.
Any further questions? Anybody want to speak one way or the other? Is there a motion, Senator McClellan?
Unless there's a motion to amend the bill, I would move to report.
Okay, it's been motion been made to move to report the bill, Senate Bill 474. All in favor of the motion, vote aye. All opposed, vote no.
Ayes 9, no 6.
9-6, the bill passes. Yeah, Senator, yeah.
Senate Bill 295, as I said, was a bill whose intent was to make the behavioral health docket available to more defendants in general district court. I think Charles has an amendment to the bill.
Yes, Mr. Chair.
295.
The amendment is on line 43, after the word including, insert referral to screening for.
Okay. Is
Okay,
there a
I'll move the amendment.
Is there a second? All in favor of the motion, say aye. Aye. All opposed, no.
There was a dispute between the Office of Executive Secretary and the General District Court judge who asked me to introduce this bill. And I think this language comes from the Office of the Executive Secretary and is designed to solve the problem.
Okay.
So I think there's peace in the valley on this bill now.
That's correct, Mr. Chair.
Is there a motion to report the bill? Senator Morrissey.
Yep. Mr. Chairman, last year when I introduced legislation, or the year before, to expand mental health dockets in Virginia, rural Virginia, allowing them to create it, I remember the Office of the Executive Secretary was against it because I wanted to codify what had been doing in some situations. Can you distinguish what this bill does, given that the Office of the Executive Secretary was against my codification and now they're...
Well,
Senator Deeds.
I don't know that I can fully explain it, but I can tell you that my General District Court judge wanted to basically override views of prosecutors and be able to put felons in drug court, in General District Court. And the Supreme Court, the Office of Executive Secretary, was not in favor of that approach. This language just makes clear that whoever is subject to a drug court recommendation has to be screened for it first. Is that correct?
No.
Your
name?
Jennifer Gilmore, Office of the Executive Secretary. Mr. Chair, Senator Morrissey, I can't speak specifically to what the objection was last year. I will say that a committee of district court judges was concerned that this bill was essentially saying a district court judge could require participation in a very intensive mental health court docket. And what the language that we asked Senator Deeds to include would essentially say that the defendant would be required to participate in a referral, but these very specific requirements of the mental health docket would still be that the Commonwealth, the judge, the Behavioral Health Committee, and Defense Counsel and the defendant would have to agree that he was eligible and an appropriate person to participate in the docket.
Okay, thanks.
So,
any further, Senator Morrissey?
So this bill then does water down what was done last year and has the ultimate effect of preventing somebody who could benefit from the mental health docket from getting into it. It limits their ability to participate in it, doesn't it?
Mr. Chair, Senator.
I disagree with that. I think it's
Senator
designed
Morrissey.
to make sure more people can get into mental health.
Okay.
It was my understanding that the intention of the bill was to allow earlier intervention to have someone participate in the mental health docket.
All right,
Okay,
I appreciate
Senator Morrissey.
your
Okay,
comment.
any other questions? Yeah, anybody want to speak? Yeah, come on up.
Chairman, members of the committee, Maria Jankowski, Indigent Defense Commission. In answer to Senator Morrissey's concerns, I appreciate your concerns. I actually don't think it limits. I think it allows for earlier intervention. The concern that we talked about with the courts were almost forcing someone who may not necessarily have had an opportunity to talk to counsel and fully consider the intensity prior to making that decision.
Mr. Chairman, my
Yeah,
concern
Senator
is
Morrissey.
assuaged. Thank you.
Yeah, okay. Any other questions? Is there a motion?
Move to report.
It's been moved and second to report the substitute, or the bill is amended, I believe. The bill is amended. All in favor of reporting Senate Bill 295 as amended, vote aye. All opposed, no.
Ayes 15, no zero.
Okay. Senator Dees.
Thank you, Mr.
Senate
Chair.
Bill 296.
296. Now, what this bill does is put back into the code language that we struck last year when we took we repealed the death penalty. This is the language that goes in the mitigation during the sentencing phase of a trial. Senator Morrissey correctly pointed out that this bill limited this language to consideration only when a jury was doing the sentencing, and since that will occur in only limited circumstances anymore, we have an amendment that fixes that, I think. Is that correct, Charles?
Yes, Mr. Chair. So the amendment is after line 58, which is the end of the bill, insert any relevant evidence and facts and mitigation that may be considered by a jury when ascertainment of punishment by a jury has been requested by the accused, also may be considered by the court when the court fixes punishment.
Okay.
I'll move the amendment.
Is there a second? Second. All in favor of the amendment, say aye. Aye. All opposed, no. Motion carries.
And so that's simply what the bill does, just allows evidence that, it puts the language that word for word was in the code prior to the time we repealed the death penalty to still describe the mitigate, with that limitation, mitigating evidence that can be presented in the sentencing trial, sentencing phase.
Is there a motion to report the bill as amended? Been moved and seconded that the bill be reported as amended, Senate Bill 296. All in favor vote aye. All opposed vote no.
That's 15-0.
15-0. Okay, Senator, let's see, who else?
Serval.
Senator Serval. 669, alleged wrongdoing of law enforcement employees. It's been moved and seconded to substitute to Senate Bill 669 be adopted. All in favor of the vote, motion say aye. Aye. All opposed, no. Motion carries. Senator Serval.
I have my other substitute. Thank you, Mr. Chairman. This bill is, as amended, is pretty simple. It basically just says that whenever anybody files a complaint against a law enforcement officer, the law enforcement agency is required to give them a receipt. So there's clarity that a complaint's been filed. I had a constituent who was invited to file a complaint by the state police. She filed the complaint, and then 2 months later, they claim they never got anything. And so this just makes it clear that somebody knows they got a complaint. So it requires them to give a receipt. Okay. Secondly, it says that they have to give the person filing the complaint a summary of their rights when they file the complaint. And lastly, it says that they have to tell the person when the complaint's been finalized, not the results. You don't have to tell them what the results of the investigation, just that it's over. And it also says that if it's ever reopened, they have to give them notice that it's been reopened for some reason. But it doesn't let the civilian get into the details of it about what they determined or what they found or whether they fired somebody. It's just so they know their complaint's been received, their complaint's been resolved. That's basically what it does.
Any further questions? Anybody want to speak in favor of the bill?
For those attendees in the Zoom who would like to speak in favor of the bill, please raise your hand electronically now.
Mr. Chair, can I ask Senator Serval
Yes, Senator Dees.
Senator, this dramatically scales the bill back from what it was when you introduced it.
Yeah, I had some language in there that got totally misinterpreted by some law enforcement agencies, which I've just deleted because it wasn't really necessary anyway. And there was also some other information that was in it about time frames that required a response within certain time frames, and the law enforcement agencies didn't want to be told they had to resolve things within time frames or whatever. So I took all the time frames out.
Anybody want to speak against the bill?
For those attendees in the Zoom who would like to speak in opposition to the bill, please raise your hand electronically now.
Okay, is there a motion? Motion to report, motion.
They don't have an objection to it anymore, I don't think.
There's a motion
They don't support it. They have no objection to it.
A motion to report the substitute to Senate Bill 669. All in favor of the motion, vote aye. All opposed, no.
No.
That's 13-0, 2 abstentions.
Okay, Senator
I
Serval, you got another bill.
I meant the other one.
I
have a substitute on the other one.
Tactics during custodial interrogations of a minor.
Mr. Chairman.
Is there a motion to adopt the substitute? Is there a second? All in favor of the motion to adopt the substitute to Senate Bill 746, vote aye. Vote aye, say aye.
Aye.
All opposed, no. Motion carries.
Thank you, Mr. Chairman. So this one, I think is a little more complex, but basically what it does is it prohibits law enforcement from lying to juveniles during an interrogation, or it makes any evidence obtained as a result of lying to juveniles inadmissible, is basically what it does. And I've been through multiple drafts of this, trying to get it right. This is probably like the 6th draft. But it basically applies anytime a minor is stopped or in an investigatory detention or arrested. That's picked up on line B. And in subsection C, allows the government to overcome the presumption of inadmissibility if they present evidence to show that the statement was voluntarily given. And it puts the burden on the Commonwealth for that instead of the accused person. But, I can't tell you how many cases I've had where, there'll be a car full of kids, cops will pull the kids out of the car, put them on the curb, break them apart, say, well, he says, the beer in the back was yours. You go, oh, what? Oh, okay. And these kids are not, their brains are not in a position to where they're developed enough or sophisticated enough to be able to have those kinds of interactions. And so this just says that a police officer can't lie to a child to get them to confess to something. They'll still be able to lie to adults. This bill doesn't go to that. It just has to do with kids.
Senator Norman.
Senator Serval, you just touched on the concern. It's somewhere in the crevices of my mind, I thought the United States Supreme Court had said that law enforcement officers could lie and then use the evidence that was shared with them, even though they had misrepresented what happened. So what are we trying to do? Make a bright line of distinction on juveniles?
Right. You can lie all day long. Law enforcement can lie all day long to adults, just not kids, under this bill.
You can't lie to kids. Okay, any further questions? Anybody in for the bill want to speak?
For those attendees in the Zoom room who would like to speak in support of the bill, please raise your hand electronically now. Mr. Chairman, we have like 6 hands raised.
Okay, go ahead. Yes, Senator Stewart has a question.
So, Senator Serval, if the parent is with the minor child, can the officer then lie?
Yeah.
No. I think the government could show, again, under subsection C, the government could show that they could try and overcome the presumption by showing the statement was voluntarily given with their parents sitting next to them. They could try to show that, but it's a presumption that can be overcome.
Okay, got some people in favor. Laurie Roberts?
Hello, can the committee hear me today?
Yes.
Thank you so much. Hi, my name is Lori Roberts. I am a policy advocate with the National Innocence Project. We are a national legal organization that works to exonerate the wrongfully convicted. And we are strongly supportive of SB 746 to prevent wrongful convictions of juveniles stemming from false confessions. We have discovered through DNA-based exonerations that false confessions are the most common contributing factor among homicide exonerations and present in 30% of all exonerations proven through DNA. And I have heard the committee reference the Supreme Court. The Supreme Court does permit law enforcement to use this false evidence ploy, but what we have learned from studies is that this deception, especially when the suspect is a minor, dramatically increases the risk of false confessions. For example, one leading study of 125 proven false confession cases found that 63% of false confessors were under the age of 25 and 32% were under the age of 18. And the reason why this is particularly important is that when someone is wrongfully convicted, that leaves the true perpetrator in the community in a position to commit more crimes. And in our analysis of DNA exonerations involving false confessions, we found that the real perpetrator went on to commit and be convicted of 48 additional violent crimes, including 14 rapes and 25 murders. That's why global police training organizations like Wicklander Zulawski have developed new techniques that reject the use of deception because they recognize that this technique can lead to false confessions. The only other thing I'll just mention, just very quickly, is the example that we have not seen the substitute language, so I can't speak to that. But one thing I would add is that the state ought to be, we would recommend that the state also needs to be able to prove reliability, not just voluntariness, but also reliability of a confession.
All right, thank you very much. Next, I'll give you 30 seconds since you're all in favor of the bill. James Dodd.
Thank you so much, Mr. Chairman. James Dole from Human Rights for Kids. Just want to echo comments from the previous speaker and highlight that when we look at exoneration rates for children who falsely confess to crimes that they did not commit, there's a large number of those children who are under the age of 18. So 36% of them who are under the age of 18 falsely confess. The lower you go in age, the higher the increase in false confessions. 67% of children under the age of 16 falsely confess to a crime that they did not commit who were later exonerated, and 87% for children under the age of 14. This bill is important to make sure that those protections are in place and that kids don't falsely confess to crimes. Thank you.
Judd Harrison. Judd Harrison.
I'm Jude Harrison.
Okay.
That's okay. I'm Jude Harrison, Director of Communications for LRID. We strongly support this bill for obvious reasons. Deceiving a child, that's very easy to do and should not be used as a part of a confession.
Okay, thank you very much. Teresa Champion.
Good morning again. Thank you very much. We support, Virginia Autism Project supports this bill. We think it's very necessary because in Virginia, if you are about to criminally hold children responsible for their behavior in schools, bills that you are passing now, then the least we can do is make sure that they're not deceived when they're being questioned.
Okay, thank you. Leni Lau.
Leanne Lytle, thank you for hearing me. I've spent my career both in education, in mentoring, and I'm a child development professional. And I want to underscore that trust is an important thing to build with youth. And we have an increasing issue with trust in our communities and the divide between law enforcement and the community. And this starts at a young age. So in terms of working with children, it's important to not lie to them because they need to learn that the adults around them and in their communities are trustworthy. So they need to not be lied to. Okay. And then the second piece is that, to the senator's point, their brains are not developed enough, and there is a differential in power between a child and an adult. And it's not fair to use coercion techniques and lies because, and that's why I think you see the higher rate of false.
Good. Okay. Thank you very much.
Yes.
Yeah, Valerie Slater. 30 seconds.
Good morning, Mr. Chair, members of the committee. Rise for Youth, the NAACP, and the Activated People, we all support this bill. We all know that youth are particularly susceptible to deception, and during interrogation, because they have a propensity to favor short-term gains, they want to end that interrogation as quickly as possible. They're just looking to get out of that situation. And so we've got to stop this practice of lying to young people, because in order to get to the truth, they ought to be told the truth. We need to hold law enforcement to that same standard. So for all of those reasons and those previously stated, we support this bill.
Yeah, thank you very much. Anybody want to speak in opposition to the bill?
For those attendees in the Zoom room who would like to speak in opposition to the bill, please raise your hand electronically now. Mr. Chairman, we do have one person online.
One person, okay.
Mr. Chairman, before Mr. Green speaks, because he hasn't seen the substitute, could I just make one thing clear?
Yeah. Senator Serval.
The bill only applies in a place of detention, which under the statute is defined as a police station, sheriff's office, jail, detention center, or other similar facility. So it doesn't apply out on the street.
Okay. All right. In opposition, Nick.
Make a motion.
No, I can't. Nate Green.
Good morning, Mr. Chairman, members of the committee. My name is Nate Green. I am the Commonwealth Attorney in the city of Williamsburg and James City County, speaking on behalf of the Virginia Association of Commonwealth Attorneys. And I guess I need to start with trying to clear up the misconception that police can just lie to people, and it does not ever get weighed in court as a factor in whether any statement, whether it be an adult or a juvenile, was made knowingly, intelligently, and non-coercively. That is taken into account. And when the police lie to people, there is going to be a hearing on whether or not that deception was so coercive that it overcomes the knowing and voluntarily confession.
Right.
And when it's the juvenile, it's even more important as to what level of deception, what level of knowledge the juvenile had.
Okay.
All of what is being protected here is already protected in courts with motions to suppress, and the Commonwealth does have to show by a preponderance of the evidence that the statement was made knowingly, intelligently, and voluntarily. What this does is it now all of those hearings done at trial and trial by ambush, as opposed to in a hearing in which a constitutional suppression is done, and then the Commonwealth would have an opportunity to appeal if the court rules that the confession was not obtained voluntarily. Now it's done at trial with no ability for the prosecutor or for the Commonwealth to have someone take another look at it. And for that reason, because we believe all these protections already exist in case law, that we oppose the statute.
Okay, thank you. Senator Morrissey, I think you have a question.
I have a question of Mr. Green. Mr. Green, in that situation where a 15-year-old is brought in and has a custodial interrogation, and the investigating detective lies to the individual and says, all three of your buddies told us this, we know you did this, and then the person gives a confession. Assuming that he's been read his Miranda rights, if that was challenged in court, that would still be deemed by a judge, if he confessed, pursuant to the lie, to be a knowing and voluntary statement, right?
No, I would just, Mr. Chairman, I would disagree with that. I mean, obviously, I was provided with very limited facts, but the court would look at much more than that. The court would not just look at, were you provided with your Miranda warnings? That would not be the end of the analysis. They would look at what all of the facts and circumstances were. What exactly was said? How old is this individual? What is their experience? If they're incredibly inexperienced with the criminal process, then that would change dramatically from a 17-year-old that has a tremendous amount of experience with the criminal justice system. So rather than making it a one question, the courts look at the full body of facts and circumstances to determine whether or not this deceptive practice by the police was enough to make it coercive.
Okay.
So I do disagree that just
Thank you very much.
just Miranda.
Senator Sherrill, isn't that what the bill does, pretty much?
Yeah.
Yeah, that's exactly what the bill does.
Mr. Chair.
The burden is still, the Commonwealth shall bear the burden of proving the statement was voluntary upon it based on the totality of the circumstances. Yeah, Senator Boysko.
Thank you, Mr. Chair. So,
No.
Senator Surville, when you were describing the bill, you talked about kids being in the back of a car and being pulled out of a car by a police officer. Do I understand correctly that the substitute as written would not protect those kids?
Correct.
I would like to offer an amendment that would include protection for that kind of a circumstance.
I think you're
don't have the
looking to
language.
strike lines 18 and 19 and conducted at a place of detention on lines 20 and 21. I think that would do it.
That's correct, Mr.
So
Chair.
moved.
Okay, it's moved to strike lines 18 and 19, which states, place of detention means a police station, sheriff's office, jail, detention center, or other similar facility in which suspects may be detained.
And conducted at a place of detention on lines 20 and 21.
And also going on, any communication made by a minor as a result of a custodial interrogation conducted at a place of detention after 2022 should be presumed to be inadmissible.
You're just striking.
That's what I'm saying, you're striking that line, 20 and 21?
You're just striking conducted at a place of detention.
Okay, so you're striking on lines 20, conducted at a place of detention.
Right.
Mr. Chair.
Okay, those two.
Mr. Chair.
I just want to read, is that the motion?
Yeah.
No,
Okay.
not quite.
Yeah, go
Would you
ahead.
please look at line 26? I think we need to strike the.
Let's do one at a
last
time.
word.
We got one motion to strike the language I just mentioned, 18
Oh,
and
yeah,
19.
Senator Morrissey's right.
All right, you want to redo the motion?
No, we just need to add add a place of detention on line 26.
Mr. Chair.
Okay, lines 18 and 19, and also at a place of detention in lines,
26.
but too many things here.
It's on line 26, Mr. Chairman.
All right, wherever, wait a minute, lines 18 and 19, and then which line?
20, 21, and line 26.
20 and 21, where it says conduct at a place of detention, that's to be deleted, and then the other line,
Line 26, at a place of detention.
at a place of detention, in two places, line 26. Does everybody understand this?
Yes, may I ask a
Okay,
question
yeah,
before we
go
take the
ahead, we've
vote?
got a motion and a second for this amendment.
Can I
Yeah,
ask
Senator
a question?
Peterson.
It seems to me like this is pretty expansive pretty broadly. It looks like you went through some process, Scott, to have it to a place of detention. Now it's going to be any conversation. No, you didn't?
All the conversation had nothing to do with that. It had to do with, it had a reasonable person standard originally, and there's no reasonable person standard with a kid because the ages is so different and their brain is so different in terms of how things are processed. That was a big part of it. And then there was some other back and forth about seizures and consensual encounters, and we took all that out. That's where all the back
All
and
right, well,
forth was.
here's my problem is that.
Senator Peterson.
Yes, thank you, Mr. Chair. You define custodial interrogation. Of course, there's more volumes than could fit in this room about what a custodial interrogation is. You actually define it as any interview with an investigatory detention or arrest, and then there's questions reasonably likely to elicit responses. So a police officer pulls over a car, police officer stops somebody, any type of Terry stop, basically.
As soon as the car is stopped, that's an investigatory detention. That's clear. What's
okay?
Consensual encounters is a little less clear. So if you got kids in the street, officer just walks up and starts asking questions. There's a fuzzy line as to when that converts.
Let me move
Senator
forward.
Peterson.
How about an SRO at a school? If an SRO comes up to a student and starts speaking to that student, would that be a custodial interrogation?
It's fuzzy. It depends
That
when
is fuzzy.
it depends on sort of the nature of the questions and what the circumstances. They take the kid into a room, close the door. There's other people present. There's all kinds of factors that play into whether or not it's turned into an investigatory detention versus a consensual encounter.
Okay, I'm just saying that if we broaden this, it's going to get a little bit tougher to make this to the finish line, but.
Mr. Chairman.
Okay, we have a motion. Is there?
Another question?
Yes, Senator McDougal.
Mr. Chairman, so if I'm going up what Senator Peterson just said, so if an SRO approaches a kid in the principal's office and asks them a question and says, little Johnny or little Susie said you did this, but little Johnny or little Susie never said anything, then anything after that is not going to be admissible.
Senator Sherwood.
Not exactly. First of all, you'd have to reach the threshold of whether or not it was an investigatory detention or not. And
Okay, well, they're in the principal's office and they can't leave and law enforcement comes in. So I don't know how that's not going to meet your custodial interrogation standard.
But first of all, that's the first threshold question. Is it a custodial interrogation? And you get into issues about whether they're free to leave or not and who was present and what they're being accused of, whether they're telling them that I think you did a crime. There's a whole series of, I don't know, there's a couple cases that have about 10, 12, 15 different variables about it. But I understand the door is closed. That doesn't necessarily convert it into an investigatory detention, but there's an argument there, okay? That's the first argument. The second thing is that assuming you hit that threshold that you're into an investigatory detention, then all it does is create a presumption. And then the Commonwealth would have to show that the statement was otherwise voluntarily given. You think lines 26 and 27, or 26 through the end. And so the court looks at the totality of the circumstances to decide whether or not, under the circumstances, it was coercive or not, but it puts the burden on the Commonwealth instead of on the accused in that scenario.
Okay. Mr. Chairman.
Senator Peake.
I think we have a motion on the floor, which is the substitute to drop at a place of detention. Is
Right.
that correct?
That's where we are.
Speak to that motion.
Yes, Senator Peake.
Thank you, Mr. Chairman. I would vote for the bill if it has at a place of detention. I will not vote for the bill if you remove at a place of detention. So I would ask that we vote against that motion.
Speaking to the motion.
Senator Morrissey.
Senator, I would, with regard to what Senator Peake said, I understand his position, but most of these custodial interrogations are going to occur at the scene where the defendant is taken out of the car, often put in handcuffs, and it's clear that he or she is not free to leave. If we water it down by only putting in this brick and mortar building, we are eliminating all of those situations where the police officers lied to the individual while they were most assuredly and measurably in custody. So,
all right.
Second substitute, move the vote.
We have a motion before us to adopt the substitute.
Adopt the amendment.
The amendment the amendment that was on lines 18 and 19, and then place of detention in 21 and 26, right? Okay, we have that motion. All in favor of the motion, vote aye.
Aye.
All opposed, no.
We do a recorded vote?
I think the ayes passed. Okay. All right, so there's been a motion to report Senate Bill 746 as amended.
Mr. Chairman, let me make one comment.
Senator Steve.
Nate Green, the Commonwealth's attorney, made a good point that as written, this objection could be raised for the first time at trial, which is not when the objection should be raised. We have, and this is perhaps for the future, we have a code section in Title 19.2 that describes the various objections that must be made before trial. And so as this bill progresses, the patron may wish to add that code section to the bill and include in that code section this section.
I'm happy to do that.
So
right now.
So in other words, we'll make that motion later or some, if you want to.
Right. The code section is 19.2-266.2. You would add that code section to this bill, and in that code section, you would add this section that the bill creates.
Right, just to cross-reference to the statute.
That means the motion would have to be made pre-trial.
Yeah, I'll make that motion. I think it was seconded.
Mr. Chair, question of counsel.
Senator Morrissey.
I would ask staff, in that situation where an individual realizes, defense attorney, for the first time at trial, that there was a problem with it could be failed to advise him of his Miranda rights, but there was a legitimate reason to make a motion to suppress in court because of what they're hearing for the first time, doesn't the judge have the discretion now to allow that motion to suppress to be considered in trial?
Mr. Chair, so the section 19.2-266.2 does provide the circuit court may, however, for good cause shown in the interest of justice, permit motions and objections to be raised at a later time. So it could be brought up in trial if the court finds there's good cause shown in the interest of justice. So to address Senator Morrissey's concern, yes, it can be brought up later, but the idea is these should be brought up all pre-trial.
Sure.
Do we want to make this motion now or not?
I did.
The amendment.
I did.
You have another amendment. Okay, it's been moved and seconded the amendment of 19.2-266.2 be added somewhere in the bill. All in favor of the motion, vote aye. Aye. All opposed, no. Motion carries. Okay, now we have a bill that's been amended. A substitute has been amended. All in favor of Senate Bill 746 as the substitute and as amended, vote aye. All opposed, no.
Ayes 9, no 6.
9 to 6, the bill is reported. I think that concludes the whole docket. So, congratulations. We got out at 10:11 a.m. Not too bad. Could be worse. So with that, the Judiciary Committee is adjourned.